everybody? How is everybody? Please smash that like button on your way in. And then we will get to it. So right now I'm going to share my screen. And this is Barry is in court this morning, and I will get to everything that's going to be happening this morning. As we wait for everybody to get in, this is Barry arriving at court this morning. And there's the daughters in the 6-inch heels again. And well, they are fighting hard to have this case dismissed. I'm going to go over all that. Let people get in here, and then we are going to go over it all. Let me start giving some shout outs. Hello, Maureen, Blue Topaz, Krista, Kayamari, Jean, Nana, Leslie. Hello, hello. Andy, Cindy, good morning, everybody. Des is on her way home and will be in a few minutes. As we all know, maybe I'll go over that first. The judge has banned any tweeting or anything from the courtroom, so I will only be able to update you guys on what is actually happening, what the judge is going to order, and stuff like that when the reporters not in the room can go out for a break. So let me get into this. The prosecution is finally showing some steam here. They're going to fight this like you wouldn't believe. We're going to go over that, and I'm going to show you what is happening. Okay, so let me stop sharing that. Let me get the other stuff up here for you so we can go over it. Okay, let me share my screen. Okay, so this is what's happening, okay? So Iris Eaton, let me get to it, you guys, and you guys will see everything that is going on right now. Iris Eaton has filed a bunch of motions. Today, as you've seen, Barry and the daughters again coming into the courtroom, acting all honky-dory, and they don't got a worry in the world. So I'm not going to show, there's 7 pages here. A lot of this is citing other cases and stuff like that. But this is what's happening. Based on discovery received during and after the hearing on the motion, Barry Morphew supplements his motion for discovery sanctions and for punitive contempt sanctions as follows. Hang on a second, you guys. So what they are saying, okay, and we're going to see it here is, and I want to bring this out first. What they are saying is they're basing a lot of this on the prosecution not handing over evidence, especially they're going against Cahill. They're really going hard on this Cahill thing. Cahill is under investigation for he shot himself in his hand at his home. Okay, so there's an investigation going on with that, and they are citing that they didn't give that information to the defense during the hearing where, you know, it was set over to go to trial. Okay, and they're saying that if they had given that information, that there is a massive amount of exculpatory evidence, and that is one of the things they're focusing on this investigation with Cahill. Another thing they're honing in on is a comment that he made saying that he didn't find that it should go ahead yet, that it's not the right time to do the arrest, stuff like that. Now, that's all oral stuff. That's an officer talking to excuse me, I got the hiccups again, to another officer, that's not discoverable. Okay. Anything discoverable is things in writing, witness statements that are in writing, things that are in writing, stuff like that isn't admissible. The prosecution does not have to turn that over, anything oral like that, unless it's something that was said orally and then put into writing that it could affect the case in some way. And that's just one officer saying to a bunch of different agencies that he didn't feel that now was the right time. He never said that he didn't believe that Barry was innocent or they didn't have enough evidence, anything like that. He just felt that it wasn't the right time yet to arrest him. Okay. So this is what they are saying is a vast amount of exculpatory evidence. And I've got a big announcement for you guys regarding the DNA. We're going to get to that once we get through this. Okay, so this is just going over, and they're saying this is a supplement. This is why they're going hard on this, that they feel that this is exculpatory, blah, 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 blah. Number one, no. Anything oral like that, just a comment, is not discoverable. Like anytime you open your mouth, they want that information. And it's like, no, it goes way beyond Brady rules. Okay. Also, they're saying that if they would have had the information about Cahill being investigated at the preliminary, that he would not have been, there wouldn't have been found enough evidence to send him to trial. Well, let me tell you about yourself, Iris Eaton. It happened after the preliminary hearing that he shot himself in the hand. So how can you give that evidence or give that to the defense in August when it didn't happen until December? Okay. So neither one of those things would have changed the outcome. Okay. So this is what he's saying. They're saying that during the January 22 hearings on this matter, the defense received over 23,000 pages. And we've also got much of it highly exculpatory. So in January is when they gave that information to the defense that he was being investigated, blah, blah, blah. Well, yeah, because it only happened in December. It didn't happen back in August. It hadn't happened yet at the preliminary. And even so, even if it had, and even if they had the information, that has nothing to do with the case. Zero to do with the case. Okay? So, let's see. They're saying it's highly exculpatory, which is a load of crap. They're throwing things at the wall to see what's going to stick. Most of the late provided discovery should have been disclosed 8 months ago, well before the preliminary hearing. Well, they couldn't because the only thing that they could have told them, which they were not, they didn't have to tell them, was about the comment he made. That's not discoverable, number one. And they couldn't have given the information about Cahill being under investigation because he wasn't under investigation 8 months ago or even in August because it hadn't happened yet. It only happened in December. Okay. So this, I believe, is all going to be thrown out. Okay. Again, they're saying that they issued defense subpoenas, blah, blah, blah. They're still saying that they didn't get a lot of the disclosure. And the prosecution is basically saying, look it's not our fault that you didn't have the up-to-date equipment to view what we gave you. Everything, they give this to every law firm. Okay. So when the prosecution gets all their crap together and hands it off to the defense, they put it on hard drives, they put it on sticks, they put it on discs, however they send it over to the defense. This doesn't mean that they did not give the defense that information. What they're saying is it's not our fault that you could not open it. And when you brought it to our attention that you were having trouble opening some of the files, number one, your IT team should be taking care of that. It's not the prosecution's job to get your IT team and your equipment up to speed. Okay. So they're saying additional exculpatory material covered by new disclosures. Cahill, arresting Mr. Morphew now is the worst decision that you can make. Now, that's not discoverable. It's a comment that one officer made to another. Okay, in his opinion, that would not have changed the outcome of the preliminary. And it goes on to say, like, we had heard already about this, that Cahill had said, look, I was into a military school. I only got to read 19 pages. I didn't get to read the whole thing. They're trying to make him say that he did read the whole thing when he didn't. So it's a lot of repetitive stuff that's being said here, that they're trying to still stick to the wall. Okay, so if you want to read through this, we've already gone over it before, but they're just now they're coming at the prosecution again. In the interview, Mr. Cahill also stated that he shared these opinions and reasons for his opinions with Agent Graham. Now, one cop talking to another cop is not exculpatory. It's not, just because one cop says one thing, they're entitled to their opinion. It's not going to change the outcome when you've got the FBI and all these other agencies that feel it's going to go through. It wouldn't have changed anything. So it's just like they're grasping at straws now at this point. And they're trying to do this, you guys, because their whole case now is built on, or was up until the Cahill thing, this DNA. We'll wait till you hear about the DNA. Okay. So they're talking about this comments that he made again. They're saying due to lack of production of this information prior to the following critical hearings in 2021, August 9th, 10th, 23rd, 24th, September, October, and November. Okay. That's when the preliminary hearings and the motions and everything were going through. Well, it hadn't happened yet. Okay, so then in January 23rd, 24th, and February 1st, the defense was unable to reveal or present the court the fact that the arrest warrant affidavit contained falsehoods. Now, they're saying here that it contains falsehoods, but they're not including what they say in that warrant that's false. So you can't just leave that wide open. You've got to, and they should know better. They should include where in the affidavit and what falsehoods or misrepresentations they are speaking of. This is a fishing expedition again. So the defense was unable to investigate and present this highly exculpatory information in the preliminary hearing and in the multiple hearings and motions for sanctions, which is a load of crap. Here, they're just citing a bunch of different cases that they're trying to go off of, etc. I think they are just pulling a lot of these cases. Like I said, later, if you want to go back and read all this, you can. To me, it's just garbage. They're pulling bits and pieces from each case, and words that they feel will fit their purpose, but not in its entirety. So they're saying that the probable outcome of the preliminary hearing would have been different if the exculpatory evidence had been produced, which is bull. The bottom line is stated in People versus Lee, in other cases where there is willful misconduct or a pattern of neglect demonstrating a need for modification of a party's discovery practices, there's a rationale for a deterrent sanction. So they're trying to say, look at all these people, they got sanctions because they didn't do this, they didn't do that. Well, the defense has been giving things as they've gotten it. Just because the defense could not open it because their stuff wasn't up to snuff, or their IT team couldn't figure it out, that's not the prosecution's problem. But the prosecution did say, well, let us get it all together again, which takes time, and get it sent over to you in a different format. So maybe you can open that. So it's not that they didn't send it, okay? But this is what they're trying to project with this new judge, right? Because of the multiplicity and considerations involved in the uniqueness of each case, great defense is owed. They're just citing other cases here about sanctions and stuff. At the hearing on this motion, Mr. Morphew requested a meaningful remedy from this court. After reviewing the newly provided information, where Mr. Morphew is convinced more than ever that the only remedy is dismissal of this case in its entirety. That's what they're going for. They are in court today. It's an all-day hearing, and there's going to be multiple officers from multiple agencies that are going to be called up, and they are going to try and have this thrown out because they're going to say that the prosecution did not give them all the information from the police force and other information regarding Cahill, which only happened after the preliminary hearing. Okay, had withheld information been available at the preliminary hearing, and it is certain that the probable cause would not have been found. Well, probable cause still would have been found because the judge that heard it for the probable cause hearing is the same judge that signed the warrant. So there was going to be probable cause, and the only thing really, in my opinion, that was at question was whether he was going to get bail or not. And we all seen what happened there. So the facts of this case, as this court has seen through the submissions, and they're going to be ruling on all this today, you guys. So that's why I wanted to get it out. Exhibits and evidence warrant the most severe sanction. There is no way to remedy the damage that the governmental misconduct has caused. The preliminary hearing indisputably violated Mr. Morphew's due process rights and would not have resulted in the finding of probable cause. Well, they're full of crap. Had the evidence not been withheld. The intentionally and pattern that have been demonstrated cry out for a powerful and severe sanction to deter the outrageous government conduct witnessed here. The court should find powerful guidance of the court appeals, which conclude that when the integrity of the court is compromised, as here, the overzealous prosecution dismissal of the case is an appropriate remedy. So they cite some more cases here. Under the circumstances of this case, no remedy short of dismissal is appropriate. The promise of Brady versus Maryland that due process clause will protect a defendant from a prosecutor who withholds exculpatory information ring hollow when a prosecutor disregards her obligations in the hopes that no one will find out. The deterrent sanction of dismissal is not appropriate in this case. When would it be? So it's abundantly clear that the prosecution not intentionally withheld massive amounts. Again, massive amounts is bull. We're going to see that. I'm going to bring that to you. Of exculpatory evidence prior to the preliminary hearing, probable cause would not have been found. The only just remedy is dismissal of the case. This can be accomplished as a discovery sanction. Sanction for outrageous governmental misconduct. Now, the outrageous governmental misconduct is huge, okay? And what you need to reach that level has almost never been met, okay? In all the years that the prosecution can remember, there's only been one case that was ever met. And this case surely does not meet the outrageous governmental misconduct rules, okay? So here it is again. You see this? This is when it happened, December 13th, with Cahill shooting himself in the hand. Okay? So let's get on to this. Now, the prosecution is firing back. Response to defense supplement to motion for sanctions. Comes now the people of the state of Colorado. This is 9 pages, and I'm going to be skipping through a lot because a lot of it is just them citing cases themselves. But there's a few things that I do want to let you guys know in here, and wait till you hear about the DNA. Okay? Comes now the people of the state of Colorado by and through Linda Stanley, district attorney so Linda Stanley did this document for the 11th Judicial District, and by and through her duly appointed deputy district attorney, and respectfully submits to this honorable court the people's response to defense supplement to motion for sanctions. The defendant has been charged with 1 count each of first-degree murder, tampering with a deceased human body, tampering with physical evidence, possession of a dangerous weapon, and an attempt to influence a public servant for events that happened on or about May 9th, What? Oh, they did a boo-boo. That should be on or about May 9th, 2020, not 2021. Wow. That's a little disturbing coming from the prosecutor's office. But anyway, it's a typo. The people have produced tens of thousands of pages of discovery and hours of video, audio recordings. The people have conferred with the defense on multiple occasions and provided discovery in a timely manner. It should be noted that it appears the defense has stopped trying to confer with the people, which means they've broken down in communications and they'd rather just go in front of the judge to try and make the prosecution look bad. We've seen this in the Valodebo case. Let me just take a sip of my coffee here. I'm just going to scroll a little bit. Yes. Please do not mention other creators. It's scrolling right across the bottom of your screen. Elizabeth, thank you so much for your super chat, super sticker. It's very much appreciated. I appreciate you so much. It gives me the incentive to keep on going. Yes, Linda Stanley is coming out in full force now. Momo for us for 57. Thank you, thank you, thank you. I appreciate your super sticker. Like I said, it helps keep me going and shows your appreciation. So thank you very much. I appreciate you. Both of you, Elizabeth and Momo. Okay. Where was I? Okay, provided in a timely manner. Okay, so here we go with this. They did provide it in a timely manner. It's not their fault that the defense couldn't open it. They didn't have the equipment to open it because their stuff is not up to date, whatever. Their IT people should have been able to take care of that if they were good IT people. But instead, they tried to say that they were giving them information in format that they could not access. So she says it should be noted that it appears the defense has stopped trying to confer with the people, as their last request for discovery was made directly to the court before the last hearing. Despite this, the defense persists on filing discovery motions asking this court for the doctrine sanction of dismissal for what amounts to disagreements among law enforcement in timing. In the defense's latest motion, they are asking the court to dismiss a first-degree murder case because a former CBI agent who has been thoroughly discredited has opined on the timing of arrest of a defendant in this case. There's some words missing there, but anyway. The defense contends that if they had known about this opinion, they could have cross-examined the agent and the case would not have been bound over for trial. This is utter nonsense. Of course, these attorneys have also had, okay, let me get my tongue working right here. Of course, these attorneys have also advocated preposterous notion to this court that the 11th Judicial District, my tongue is not working today, DA's office, the FBI, CBI, and the Chaffee County Sheriff's Office are in some grand conspiracy to suppress discovery that we have already timely provided. Oh, she's coming out, guns blaring here. Facts. On December 10th, okay? So the hearing, okay, that put Barry over for trial, okay, happened in August. Facts. On December 10th, the people received what is referred to as a Brady letter from the Colorado Bureau of Investigation regarding one of their agents, Joe Cahill. The letter indicated the impact on Mr. Cahill's credibility was the result of an accidental discharge of a firearm and was unrelated to the case. Okay? So, what they're saying is, oh, his credibility is no good anymore, blah, blah, blah. Mr. Cahill's credibility's out the window because he's being investigated now. He's being investigated for discharging his weapon at his home and it hit him in the hand. Okay? Nothing to do with this case. The people immediately turned that letter over to the defense. On multiple occasions, the defense demanded the people provide the Internal Affairs Investigation, the IA, on Mr. Cahill. Each time, the people informed the defense that we were not in possession or control of that file, and they would need to file a subpoena duces tecum to obtain the information. Finally, the defense did just that, although the SDT was very broad and was looking for information previously denied by the defense by Judge Murphy. So they tried to do a backdoor tactic here, thinking that this judge would have no indication of what Judge Murphy had already decided on and give them what they were already denied. So they're trying to get sneaky. They were already denied this information. It has nothing to do with the Morphew case. Pursuant to Colorado law, the court took the IA file to determine if any information was relevant to this case. On February 3rd, 2022, the court released a copy of the IA to the people and the defense. Gave it to them anyway, even though they did not have to, because it had nothing to do with this case. But to shut them up, they got it. The defense has taken bits and pieces out of context in the IA to claim there is a discovery violation, arguing that because Mr. Cahill his opinion on when the defendant should have been arrested, it is exculpatory and should have been discovered. The defense uses the statement that Mr. Cahill said, the arrest of the suspect now, as the worst decision that could have been made. Mr. Cahill also indicated in his IA that he thought the arrest of the suspect in the investigation was premature and that the arrest was hasty. It also appears Mr. Cahill was put out because he could not be present at the arrest due to him attending the arrest, even though he spent a year of his life putting together the investigation. At no time did Mr. Cahill say that he did not think there was probable cause to arrest, or that he had thought the defendant was not guilty of murdering his wife. Okay? All he said that he thought it was hasty. He thought they needed more time to get more evidence, basically. That's not discoverable. Okay? Case law. So a lot of this I'm going to just scroll through because she basically explains it anyway. The Colorado Supreme Court and the United States Supreme Court. So this is important, okay? Because when you get the Colorado Supreme Court and the United States Supreme Court making statements on certain rules, you better take notice, okay? Don't forget what she had said over here. Don't forget what was said here that she is saying here. The outrageous governmental misconduct. Okay? So that's what they're going to speak about right here. The Colorado Supreme Court and the United States Supreme Court have been explicit in the limitations of discovery in criminal cases. In general, discovery in criminal cases is governed by Criminal P16. This rule describes each party's obligation and imposes deadlines for disclosure of certain items of information. Discovery is limited to these principles. There is no general constitutional right to discover in a criminal case, and Brady did not create one. So it gives the sites what they're citing right here, citing Weatherford and everything else. As a constitutional matter, Brady and its progeny only requires disclosure of exculpatory, impeaching, and mitigating evidence. Okay? Bagley set forth materiality standard. Evidence is material only if there is a reasonable probability that the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. Okay? And they just cite other cases. Otherwise, discovery is limited to the dictates of Criminal Rule 16. Colorado remains one of the few states that has never deviated from the traditional doctrine holding that courts lack power to grant discovery outside of those statutes or rules. They cite some more here. Okay, so holding that neither the Constitution, rules of criminal procedure, nor any statute gives the trial court authority to order access to a private residence to the defense. By providing additional means for disclosure, Colorado's rules of criminal procedure to some extent compensate for the limitations on the protection afforded defendants under the Brady Doctrine, and they cite some more. Thus, under Colorado law, district courts have no freestanding authority to grant criminal discovery beyond what is authorized by the Constitution, the rules, or by statute. Sorry, you guys. The right to confrontation is a trial right and not a rule of pretrial discovery. Accordingly, in guaranteeing an opportunity for effective cross-examination, the Confrontation Clause does not guarantee every possible source of information relevant to cross-examination. The Due Process Clause does not provide discovery other than Brady, and the defendant has no right to use court-provided investigative tools to provide discovery. So she's made a good statement right here, okay? And she's basically condemning them for trying to get this judge to rule differently than what Judge Murphy had already ruled on. Due Process Clause has little to say regarding the amount of discovery which the parties are afforded. With regards to the dictates of due process, the United States Supreme Court has found at most an entitlement of access to evidence and witnesses that would be both constitutionally material and favorable to the accused. Brady and cases following it require discovery of items that are favorable to the defendant because they are exculpatory, impeaching, or mitigating. Brady is substantially incorporated into Criminal Rule 16A2. The rule requires the prosecution to disclose any, this is going to come into play, material or information within his or her possession or control, which tends to negate, Willow, get your shit together here, the guilt of the accused as to the offense charged or would tend to reduce the punishment thereof, material or information. The rule provides time limits for disclosure of discoverable materials. First, as to Sections 1, police arrest, and crime or offense reports, including statements of all witnesses, books, papers, documents, photographs, or tangible objects held in evidence. Also, a written list of names and addresses of the witnesses. The discovery must be provided as soon as practicable, but no later than 20 days after the first appearance or following the filing of charges. All other enumerated discovery is due as soon as practicable, but not later than 35 days before trial. Okay? Rule 16.1b3, Implicity Rule 16 recognizes that ongoing discovery obtained by the people and submitted to the defense in advance of the 35-day deadline is reasonable and is basically the general rule that they follow. So back in January and February, it wasn't 35 days before the deadline for the trial, right? So to the extent that the motion complains of not receiving information prior to when reports were written and evidence actually obtained, oral statements are not required to be disclosed. There is no requirement that oral statements be reduced to writing or discovered. The Denton Court held, in our view, the current criminal P16.1A1I only requires the prosecution to provide the defense with the written statements of witnesses or any written reports that quote or summarize oral statements made by witnesses. If the Supreme Court had intended that amendment of criminal P16IA1I to require the disclosure of unrecorded oral statements than it would have so specified, as it did elsewhere in Criminal P16. The substance of any oral statements made to the police or prosecution by the accused or by a co-defendant if the trial is to be a joint one. So this does not cover one cop saying his opinion to another cop. To the extent that the motion seeks dismissal, the Supreme Court in the United States, States versus Russell, held that the conduct of law enforcement agents might be so outrageous that due process principles would absolutely bar the government from invoking judicial process to obtain a conviction. The conduct, the court held, would need to be shocking to the universal sense of justice. Okay? So remember back here, the outrageous governmental misconduct, that's what we're speaking about. Oops. Okay? And this is what she's going to say here. Shocking to the universal sense of justice. Idea 432. The Colorado Court of Appeals adopted the standard and held that only where the conduct violates fundamental fairness and is shocking to the universal sense of justice would there be outrageous government conduct. Instances in which the trial courts have found outrageous governmental conduct in Colorado are rare. Okay, and they cite some cases holding no outrageous conduct where there was violation of the defendant's Fifth and Sixth Amendment rights on 2 occasions. So they cite some cases here, but and some pretty, violations of rights and stuff like that. Even though some rights were violated, even holding that there were violations of the rule and statute involving grand jury procedure, even those violations did not amount to outrageous government conduct. And they give several things that were said or done in other cases where people's Fifth and Sixth Amendment rights were violated and stuff like that, where what they're claiming is nowhere even near that. Even with those violations in the case, there was still not a finding of outrageous governmental misconduct. Okay? There is no reported case in Colorado that has found outrageous government conduct in discovery violations. Yet it appears the defense wants this court to go where the Supreme Court and the Court of Appeals will not tread. And they give some more here. Okay, so they're going to give the instance where there was one case where the Supreme Courts found that there was outrageous government conduct. And this is the only case that could be found. Incidents where a trial courts have found outrageous government conduct in Colorado are vanishingly rare. And the threshold for such a finding appears to be exceedingly high. In fact, we only found one such case where a Colorado appellate court upheld a finding of outrageous government conduct. And this is why. Upholding the dismissal of charges based on a finding of outrageous governmental conduct because the prosecution filed fake charges against an undercover agent and therefore duped the court into becoming an accomplice to their nefarious actions. The Court of Appeals reversed the trial court's order and remanded, directing that charges be reinstated. So even though, and that would be like, the prosecution is filing fake charges against an undercover agent, yeah, that would be outrageous government conduct. But this is nothing. Okay, so this is where it gets good, you guys. You want to hear about the DNA now? So, yeah, so there's no way that what they're claiming about Cahill and whatnot and what he said and him being under investigation, that is, oh my gosh, so far out of the scope of what outrageous government conduct covers that it's laughable. Okay, to me anyway. Okay, so here is Linda Stanley's argument that she is going to be arguing today. The defense in this motion and others and in argument repeatedly refers to discovery provided as highly exculpatory, and that there are massive amounts of exculpatory evidence, yet provides no specifics as to what is exculpatory, let alone highly exculpatory. These unsubstantiated statements should be considered as simply sartorial embellishments and dismissed right out of hand. Certainly, if the defense counsel calls an accusation of perjury for a witness on the stand as in the heat of the moment, these hyperbolic, unsubstantiated statements should be considered the same. The only discovery that should be considered with this motion are the statements made by Joe Cahill as part of his internal affairs investigation. The defense has provided Exhibit A, which outlines statements made by Cahill and potential questions the defense could have asked. This also should be disregarded. As mentioned above, the confrontation clause does not guarantee every possible source of information relevant to cross-examination. Furthermore, a defendant has no constitutional right to unrestricted confrontation of a witness and to introduce evidence at a preliminary hearing. Essentially, just because the defense could have asked questions based upon discovery provided after the hearing, that does not mean the Constitution is violated because they were not able to ask the questions. Looking through the list of questions the defense would have asked, it is clear that they are not material and would have had no effect on the outcome of the preliminary hearing. Such questions as the timing and when and who he told his opinion do not go to probable cause, but rather are a discovery fishing expedition. The defense also persists on claiming, as part of their grand discovery conspiracy, that Mr. Cahill's reassignment within the Colorado Bureau of Investigation after the preliminary hearing was the result of pressure by the district attorney Linda Stanley after Mr. Cahill's testimony at the preliminary hearing. The defense opines that this would not have affected the outcome of the preliminary hearing. The preposterous in that all these events happened after the preliminary hearing, and even if true, would not have affected its outcome. The people are respectively asking this court to not allow the defense to question witnesses on this matter. It is a fishing expedition that goes to nothing and feeds into the preposterous notion that we are engaged in some grand discovery conspiracy. Oh my God, please bear with me. I'm getting aggravated at myself. My tongue's not working right. The defense contends that they have not seen a single email, document, text, or report documenting that Mr. Cahill communicated the information that he disagreed with the timing of their arrest. Right. They would not have got an email, document, text, or report of documentation because there was none. It was an oral blah that he said to another officer. It wasn't documented. So you know what? Because it wasn't documented, it wasn't sent to anybody in a text or anything like that, then it's not discoverable. The defense contends that Mr. Cahill's opinion is exculpatory. It's not. Mr. Cahill's communicated his concerns verbally. There's no documentation of his opinion. Further, when or how a person is arrested are issues that are procedural in nature. They do not implicate whether there was probable cause, but merely how to comply with the court's finding a probable cause and to order the arrest. So the arresting officers have no involvement in saying whether he was to be arrested or not. They're carrying out their job in arresting a subject that is ordered to be arrested by the courts. Therefore, any disagreement between law enforcement as to this procedural issues is not exculpatory. It's certainly not exculpatory if officers disagree whether they should arrest a person at their home versus at work. Likewise, disagreements as to when to execute the court's order is not exculpatory. So, one cop could say, let's wait until he gets home, or, and arrest him at home. And the other one could say, no, let's not let his family see that. Let's arrest him at work. Those things are not exculpatory. They're opinions of officers. All they are set to do is to arrest him. Anything they have to say about the arrest has nothing to do on them. They have an order, which they were not part of making. They are ordered to do it as an officer. Go and arrest this person. So what their opinions or comments about the actual arrest are irrelevant. Mr. Cahill opining on the timing of the arrest is also not material. The standard as outlined in Bagley is that evidence is material only if there is a reasonable probability that the result of the proceeding would have been different, which it's not. It was an arrest warrant. Go arrest him. Anything that those cops could have said, nothing was going to change that order. Okay, so that's what they're saying. A reasonable probability is a probability insufficient to undermine confidence in the outcome. It is clear that one law enforcement officer opinion about the timing of the arrest would not have affected the outcome of the preliminary hearing. Of course not, because it was made after the preliminary hearing and after the decision was already made. As mentioned above, opinions as to the timing of the arrest are merely procedural. On conflicts between law enforcement agencies as to procedure, although not common, happen regularly. Nothing would have changed at the preliminary hearing should this procedural disagreement between the law enforcement have been brought to light. Although there is nothing to suggest that, as the defense speculates, that Mr. Cahill thought there was no probable cause or that he didn't think that the defendant murdered his wife, assuming that Mr. Cahill had said that, he thought that there was no probable cause, which he didn't say at the time of the arrest, it still would have not been material. In a preliminary hearing, the standard is probable cause, and the evidence must be viewed in the light most favorable to the people, which with all conflicts and evidence to be resolved in favor of the people. This is a standard followed absolutely, oh my God, I can't talk, by Judge Murphy at the preliminary hearing. He specifically mentioned the unknown DNA found on the victim's SUV and, using preliminary hearing standards, discounted it in favor of evidence viewed in the light most favorable to the people. Wait. One law enforcement officer opinioning there was no probable cause to arrest would not change this, especially Judge Murphy had found probable cause at the time of the arrest by signing the arrest warrant. But as mentioned earlier, there is no evidence of that opinion by Mr. Cahill. The defense also contains, wait, we're going to get to more of this DNA. Wait till you hear this. The defense also contends that the arrest warrant affidavit contains falsehoods and misrepresentations, but does not provide any specifics. They rely on blanket accusations with no basis in fact, leaving the disagreements about timing of arrest as in falsehoods and misrepresentations. Thank you, Kathy. I try my best, my dear. So thank you for that. I appreciate you. Okay. So the arrest warrant had already been issued. So nothing that the police had said to each other or when they chose to arrest him, where they chose to arrest him, nothing was going to change anything. The arrest warrant was already issued. Okay. And the police couldn't have changed it anyway. It was a court order. The defense attorneys have also proposed the sanction of dismissal and repeats their contention that if Mr. Cahill's statements had been known, then the probable cause would not have been found by Judge Murphy, which is bullshit. As outlined above, this is preposterous. An opinion of timing and arrest would not invalidate 4 days of testimony, especially with the preliminary hearing standard. The defense contends that the people withheld massive amounts of exculpatory evidence prior to the preliminary hearing. Well, again, Cahill wasn't under investigation until December. The preliminary hearing was held in August. It's like, are you kidding me? Oh, thank you, Momo. It's not, I mean, it's not, my tongue's not working. For some reason today, my tongue is not working. Whoops. Sorry. Sorry, you guys. Yeah, I muted myself by accident. Sorry. I was also taking a minute anyway, just to have a sip of my coffee. But I stopped here for a minute because this is the good part about the DNA. Are you guys ready? Are you guys ready? And you guys, please, before we get to this, I want to let you guys know, when the live ends, it is always gone private or something for about 20 minutes so I can get the description and everything done in it, and then it's right back up. Okay, so if you miss part of it, or if you're, starting from the beginning right now and it goes out on you, don't worry about it. It will be up within usually 20 to 30 minutes. It takes a bit for YouTube to also do that. So don't worry about it. It is going to be right back up. Okay. And I also want to let you know, good, I'm glad you guys are ready for this, because this, I can't wait. I can't wait for a break at the court, because Barry Morphew is in court this morning, and they are going to, Linda Stanley, I believe, is going to be there today, because they're going to fight all this. All these sanctions and everything, they're fighting it, okay? And the biggest one is they want the case dismissed. Thanks for covering this. Was typing to say no sound, but it's back now. Sis, love you. Thank you, sister, for your super sticker. I love you. I love all of you guys. And I want to thank you, you guys. I so much appreciate the super stickers and super stickers, super chats. Yeah, so if there is something that you definitely want me to see, because I'm looking at 3 different screens here, you guys. I'm keeping an eye on the reporters right now on one screen. I've got my StreamYards and YouTube up on another screen, and I've got all my documents up on another screen. So if I happen to see it, it comes up big on my one screen if there's a super chat or super sticker. So I generally see that, and I will stop and answer what I can right away for the super stickers. Okay. Yes. And there's how you can donate right there. Okay. So you guys are ready for this? And don't forget, this is what's being fought in court today. It is also telling that the defense is not asking to rehear the preliminary hearing as a sanction. Okay. Now, the reason why they don't want to retry it, because right now he was released on bail because the biggest part of that was because of this DNA. Okay? That although there is enough to send him, he doesn't know if he will be found guilty, because this DNA was brought up, and I've talked to you guys. If you haven't seen my video on the DNA, I suggest you go and check that video out. I will link it somewhere up here at the end of this video. It will be up at the top of the screen somewhere right at the end of this video. So check that out. I will, if I can remember, you guys know my memory, I will try and link it in the description also. But I go over that DNA evidence that was found. Now we've got more evidence that I'm going to get to it, you guys. I know I'm holding out on you, but I want to explain this. All of the DNA, Mama Shan, okay? I told you that this partial DNA that they got from the Range Rover, from the house, from all this stuff, they also now are bringing up fingerprints that do not match Barry, that are on the handlebar grips. Well, guess what? Guess who touched the handlebars of that bike? The cops, when they found it. Thank you so much, Git, for your super sticker. Thank you. I appreciate you. From Sweden to boot. Wow. I'm glad to have you here from Sweden. Thank you for joining us. I'm glad to have everybody here. So I went over that. It was a partial fingerprint that they got, and it matched a partial. It matched thousands of partial prints in CODIS, not full prints in CODIS. Okay? They matched partial prints. A hit is when it matches 100%. A partial print matched a partial print, actually matched thousands of partial prints that are already stored in CODIS. Okay? So you got a partial print that was found at the Morphew home, vehicle, everything that matched one of thousands of partial prints in CODIS. It wasn't even, yeah, it is a big, big difference because the partial print that they got didn't partially match a full print in CODIS. It matched other partial prints that they have in CODIS. So that's important, okay? And here is the big reason. The biggest reason that they were saying that to get Barry off and to have this suspect is this partial print that didn't match Barry, okay? They were using that big time, and that's why I believe he got bail. And the reason why they don't want to rehear the preliminary hearing, you're going to see it right here. Let's go. Let's go. And this is usually a sanction that defense attorneys would ask for. We want to redo the preliminary hearing for probable cause. That's number one. They usually want a rehearing. But they're not asking for that. And you know why? You're going to find out right here. So let's start again at 22. It is also telling that the defense is not asking to rehear the preliminary hearing as a sanction. If, as the defense contends, the hearing violated the defendant's due process, and with the latest information, it is certain that the probable cause would not have been found. That's what they're saying. So why wouldn't they ask to redo the preliminary hearing? Then, right here, then the natural remedy is to rehear the preliminary hearing, right? The reason is clear why they do not want to redo the preliminary hearing, because any judge will still find probable cause even with Mr. Cahill's statements. Here we go. In fact, it is arguable that a judge would more easily find probable cause, which means Barry probably would not get out on bail, since we can now show that the 3 CODIS hits presented at preliminary hearing are not connected to this case. That's why they don't want to redo the preliminary hearing, because he would be held without bail. Right? Right, you guys? Boom is right. It is also telling that the defense is not asking to rehear the preliminary hearing as a sanction. In fact, it is arguable that a judge would more easily find probable cause, which she is saying there, okay, for somebody that's like me that has worked in criminal cases and whatnot for over 30 years, she might as well have just come out and said, the judge would not have released your client on bail. Okay? It is clear there has been no discovery violation on the part of the people, and it relates to the statements made by Cahill, and the defense supplement should be denied. Wherefore, the people respectfully ask this court to deny the defendant's motion for sanctions in all of its forms. There is no basis to this. Okay? So, now with this, there's more. Yes, there's going to be a win here, I think. If this judge rules for the defense on this, the prosecution has to do something and to have this judge removed. because it's going to show bias. Okay. The only way, Mari, that the bail could be revoked at this point is to have the probable cause hearing redone. And I think the only one that can do that is the defense, if they find that there was things that, like they're saying right here. Everything that they have said, if they believed it, they would have asked. If they believed that a different outcome would have happened and their client would have been found not enough for probable cause to go forth, which is what they are saying. They want this dismissed because if they would have had this evidence at the probable cause hearing, he never would have been put over to trial. Okay, well, let's do it over. But they're not asking for that. Why? Because there's more now to prove probable cause, and he would not have been let out on bail. That's why they're not doing it. And that goes to show right there what I've said all along. They're throwing things at the wall to see what would stick. And right now, Lama is letting a lot of things stick that he shouldn't. Let's not mention that yet, Des, because I have not been able to verify it yet. But there's more. There's more. And this is kind of why I'm concerned about them getting everything they want again, even with all of this. Okay? Okay, let me just stop sharing this for a second, you guys. Just give me a second, you guys. Hang on a second, you guys. Okay, here it is here. Okay. Let me share this again. Okay, so a lot of you guys have been asking about expanded media coverage for the trial. Okay, so we know with Scott Peterson and stuff like that, it was all televised, as this one should be, right? Well, guess what? This matter comes before the court for consideration. The petitioner KOAA TV request for expanded media coverage of the jury trial set to commence on May 3rd. We're going to go right to the bottom because he goes over the standards and just explains blah, blah, blah. Okay. Okay. The petitioner seeks expanded media coverage in this case for the jury trial of the defendant set to commence on May 3rd. Denied. It's been denied. So there will be no live coverage of this trial. Not only that, he also issued this. He's already made an order on anybody else requesting to be able to cover this. Okay? The media, the public, the parties, and the party's legal representative and agents shall at all times be subject to this order. Okay, it explains that the courthouse and the facilities is a 4-story structure that houses blah, 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 blah. He's saying that access and movement within the Justice Center must remain available for the conduct of normal use. This order applies to the entire Fremont County Justice Center. So you know what? The reporters can't even go into the bathroom and sit in the bathroom and tweet out some stuff that's happening in the courtroom during breaks or anything. They have to go off of court property. See, this order applies to the entire Fremont County Justice Center and county property surrounding the Justice Center. The Justice Center property is defined as the building and public parking area. They have to totally go off of all the property to even be able to tweet anything out or put anything out there. No photography, audio, or video recording of any kind is permitted within the courtroom or in the Justice Center. You can't even bring your phone into the courtroom. You got to leave all this crap in your car. Or in the Justice Center. So no, you can't even have your phone in your car because they're saying even the public parking area. So you have to park down the street if you want to leave your cameras and laptops and phones. You have to leave it in your car off of the property of the Justice Center. No live reporting of any kind is permitted from the courtroom or the Justice Center. Right? Like, is this not, have you ever seen anything like this? That you can't even go out into the lobby or downstairs or sit in your car in the parking lot or in the bathroom and tweet something out? You're not allowed. Nowhere. In the court, in the whole court building, or in the parking lot, nothing. There shall be no cell phones, laptops, tablets, or iPads in the courtroom, except that the attorneys for the people and the defense, including their staff members, may use electronic devices to the extent necessary for the prosecution or defense of the case. Any person who operates or attempts to operate any electronic device within the courtroom used in this case as a violation of this order shall be removed from the premises and or shall be subject to contempt. Contempt proceedings. If law enforcement officer has probable cause to believe that any electronic device was used or is being used in violation of this order, he or she may immediately confiscate such device. Law enforcement officers shall have the discretion to temporarily secure any device confiscated for the purpose of conducting an investigation of the violation of this order. The foregoing provisions regarding electronic devices shall not apply to employees of the court or the Fremont County Sheriff's Office or to other law enforcement personnel or the Justice Center for law enforcement purposes. They are tripping right out. So people that work at the court can have them. It's just anybody else coming into the court is not allowed, including media. The public and media will be admitted to the gallery of the courtroom if seating is available. The court may reserve seating for the parties and witnesses. Requests for specific seating for the victims and their family members and the defendant's family members shall be made to the public information officer for the Colorado State Court Administrator's Office. Media seating based on availability will be organized by the court's public information officer. All members of the public and media shall be seated before the court session begins and shall remain in the courtroom unless a recess is called. No admittance will be permitted while the court is in session. Public or media leaving the courtroom during the court session will not be permitted to re-enter the courtroom until the next recess is called. So if you're sitting in court and it's going on for hours and hours and you're about to poop your pants, just poop your pants, please, in the courtroom. Because if you leave, you're not allowed back in until after the next recess is called. So just poop your pants there. Everybody wear Depends. Any violation of foregoing provisions and any other conduct the court finds, won't it get stinky in there? Maybe he'll change his attitude. Any violation of the foregoing provisions and any other conduct the court finds disruptive to the proceedings may result in an order of temporary or permanent exclusion from the proceedings and or contempt proceedings. A copy of this order shall be posted at the front entrance of the Fremont County Justice Center and at the door of any courtroom used for the purpose of the proceeding in this case. There you go. Yeah, the public needs to be really pissed about this. Really pissed. And I don't think I should. I can't talk about it right now, but there's something big going on behind the scenes with this too, regarding myself and another creator. So we may have a good lawsuit that we're going to file. But outside of that, they can take notes with a pen and paper. They're not allowed their notebooks. They're not allowed their phones. They're not allowed anything like that. Absolutely. And every U.S. citizen should be outraged by this. I do think that they have told her family next to nothing. I don't know. Yeah, I think the media and the prosecution, if he finds for the defense today on all of this, they do need to go higher and have this judge removed. Absolutely. Thank you, Cindy. Absolutely. And I think the media may go, because they are even keeping them from being able to live tweet or send out things on TikTok, whatever that is that they do. I usually follow the tweets from several different people that are in the courtroom, all news people. They're not allowed to do that anymore. So I do think that the media will be, because they're being barred from having their laptops or phones or anything in there, I think they're going to go higher with this. And apparently the prosecution has no problem with it being shown. It's the defense. It's all the defense. The defense trying to keep everything out of the public eye, what Barry did. And what comes out in court. Right? And that's why they're not asking for a redo of the probable cause, because they know that he would be held without bail. So I'm just going over now what you guys think. Just close that out. I did show, I can bring it back up for you if you want. For the ones that weren't here when I showed him entering court this morning. Let me see if there's anything, if there's any news out yet. Okay, I'm going to show this first, you guys. Oh, I got Cahill coming into the court. Okay. Okay, let me share this. And then I'll show you Barry. Okay, so here is Cahill coming into the court to testify. Okay, so let me find the other one of Barry this morning coming in. Oh, God, here's the ugly. Sorry, you guys, but I just can't stand even the sight of this guy. For those of you who haven't seen it yet, I will share it here. So this is Barry and his lovely daughters, and how do you think they're dressed again this morning? Let me just see. I love you, Sarah. Yeah, vomit alert. I'm just going to leave that right there for now. Look at them smiling away. Smiling at the cameras. Barry's looking awful thin. And they got little bracelets on their ankles. So this is them coming in this morning. They're not going to go out and look for him, okay, Amari? I think they know exactly. By this time, I think they know. In my opinion only. Okay, so let me go and see if I can find out anything from you for you guys. Here's something else that's interesting that I will share with you. What's her name? Hang on a second. I forget what her name is. Hang on. You guys will help me, fill me in. You guys know my memory. So there's Iris Eaton. There's Barry. And there's his little minions behind him. This is Iris Eaton. Where's that other lawyer? What's her name, you guys? These are just motions. If they are going to be called as witnesses by the prosecution, they have to stay out of court until they're called. What's that other lawyer? The other lead lawyer? Anybody? Drew Nielsen. Yeah, thank you. Mobbings. Nielsen, everybody. Thank you. Thank you. Thank you. That's it. Nielsen, yeah. JD, Nancy Drew. Well, oh, where'd that go? Martin. It was Martin. Nancy Drew. Where's Nancy Drew? I love that. She's not here. I don't know where this picture came from, but it's something that I found on another platform. I'm not going to say where. Please don't mention anything in chat, because I ain't about getting anybody in trouble. Okay, so let me go back. These are things that I'm finding as I go, you guys. Let's see. What's this? Oh, okay, hang on. Okay, hang on, you guys. I got something else here too now. Hang on. Okay, hang on. 5:13 readiness. Okay, I have some updated information here I'm going to give you guys. Let me just get this written down. Okay, so I know this is off topic right now, but I want to get it out there for you guys. Regarding Trezell and Jacqueline West. There's a motions hearing coming up on the 8th. Oh my God, I'm going to be busy on the 8th. I don't know if I can stream that, but I'm gone most of the day. But anyway, there's a motions hearing on the 8th. And then May 13th, there's a readiness hearing. And the jury trial is starting May 23rd. But as we know, this may change. Okay. I just got those, excuse me, I just got those dates now. Yeah, and that's for both of them. Okay, let me continue. I'm looking for you guys. Okay, so here's another. Okay, so one of the CBI agents in charge of investigating Barry Morphew told many law enforcement witnesses in this case that arresting Mr. Morphew was premature and the worst decision that could be made. So I'll show you this. This is from another source that's in Colorado. This is another photo of him going in. So this is outside the courtroom. I don't get it because I'm not. Yes, I thought there wasn't supposed to be allowed any cameras or anything. Okay, let me just see if there's anything else that's come out. Okay, so Barry Morphew's defense say prosecutors withheld exculpatory evidence from the court during the preliminary hearing. His attorneys state in the motion that had the withheld information been available, a certain probable cause would not have been found. I hope this judge, and this is back from March 1st, I hope that the judge rules that the pretrial or the probable cause hearing should be redone and put him right back in jail where he belongs. Okay, I'm looking for multiple accounts here, you guys, to see. Okay, let's add a search and see if I can't get anybody who's put anything up. I'm just looking, you guys, at different news agencies. Nothing out yet. I don't think there's going to be an update, you guys, until they break for lunch, which should be shortly. Okay, let me get back to the chat here and see what you guys are saying. Okay, let me scroll through this, you guys. Like I said, if you do want certain questions answered, it will pop up and I will see it because I'm way back in chat looking for questions that you guys have asked while I was reading through this. And I am keeping an eye on a couple different news agencies, and I will let you guys know as soon as something comes out. When I see Suzanne's daughters grinning ear to ear, all I can think is what could possibly be so funny. I agree. Inspector Gadget. So yeah, Inspector Gadget. Like I said, you guys, I'm way behind in chat. So if you do have a question that you want me to answer, please put it in a super chat or something so it'll pop up on my studio in YouTube. It's like they all think they're on a runway. Yeah, Steffi SG says that. Wow. Cindy says controlling them like he did Suzanne. Yeah. Yep, the inheritance for the daughters is going down the toilet. Jilly Bean. Thank you, Jilly Bean. Thank you. It is fine with me, Jilly Bean. I appreciate everything. And I'm sending my love right back to you. Thank you so much. Every little bit helps. Okay, so Deanna says, hold tight to Daddy's arm so he doesn't get abducted by a mountain lion. Yeah, a lot are commenting that it looks gross, like not the normal daddy-daughter relationship. Like I said, you guys, I'm way behind in chat here, so. There was another comment. Sometimes people change due to hardship. No change here. Nope. With their Gucci bags and Chanel belts and the real angel says, thanks, Willow and Mods. We appreciate you. Well, thank you, the real angel. I appreciate each and every one of you, too. Cuptoot, thank you, my dear. Thank you. Thank you for your super sticker. Well, thank you for all being here. Sorry, I had a cough again, you guys. Thank you so much for your donation. Okay, Amari says Cahill should shut his trap. I don't think he said anything wrong. Like, everybody's entitled to their opinion, right? And like when you're a cop and you're going out to arrest somebody, you got to follow that court order. Nothing you say or do is going to change that court order says you must go and arrest him. So short of quitting your job right then and there's nothing you can do about it. You got to do it whether you agree with it or not. So him stating his personal opinion has nothing to do with the facts of the case, right? Yeah, the girls would have to look past a whole hell of a lot for them not to even suspect that their dad did this. Okay, so I'm seeing a lot of comments. Like I said, you guys, I'm way behind in chat. So if you do want one, throw a super chat or something up there if you want me to see it right away, because I'm way behind in chat. But there was a good one here. I don't know how long ago this. Oh, where did that go? Hang on a second. Oh, gosh, where did it go? Hang on. Ashley, thank you, my dear. Thank you so much for your $4.99 super sticker. I appreciate you. Okay, where did that comment go now? Hang on, you guys. It was a good one. Oh my gosh, I don't know where it went. Ah, sorry, you guys, I lost it. It was a good question, too, and a good comment. Let me see if I can find it. And if you think I can remember it, no. Martin says send smoke signals. They can't use their phones. They're singling out Cahill. I don't think, like, Cahill's entitled to his own opinion, and I don't think he did or said anything wrong. But that's something that they could latch onto and see if it stuck, and that's what they tried to do when I'm sure that they've got the disclosure saying about the DNA evidence. I know the daughters are on the witness list, so I don't know if they are actually going to call them. You're welcome, Susan. Susan says, thank you so much for all you do. You're very welcome. Oh, yeah, I remember now what I was going to say because somebody made a comment about the judge. Now, this has not been verified. I'm going to make sure I say that right now. It is something I am going to look into. But we all know that there was a lot of evidence that the judge is not going to allow in about the domestic V, right? Those were comments from her best friend, from her sister, certain texts where she was saying she was in a domestic V situation. But the thing is with that, what I have heard, now I haven't been able to verify it yet, so please don't take it as fact. I heard that the judge's wife, when they were separating, had pressed charges of domestic V on the judge. I don't know if it's true or not, so watch for that in my community tab. If I find out that's true, then he's biased and he should be removed from this case because he has thrown out almost all of the DV evidence that the prosecution wanted to use. Yes, don't take it as fact right now, please. I was told by several different people that that was true, but I don't know for fact that it is. If it is, the prosecution should be having him removed. Okay, thank you. Thank you, thank you, thank you for your super sticker. Okay, let me jump over here, you guys. And see what's coming out. I'm checking somebody else because if one is coming out, then the other one will be. Um, Just give me a second, you guys. I'm checking a few different. And that's not true. I just checked. And I don't see anything at all. So I'll go back to my trusted one. Well, sorry, you guys. I'm just looking through my list here of people that I have in the news field in Denver. I would appreciate if people didn't mention other things in chat regarding this, please. There is no new information that has come out yet at all. I see a lot of regular people commenting and giving their points of views, but there's nothing that is verifiable. There's nothing. There is nothing from any verified source. And these are the ones that I usually get all my information from, and none of them are speaking at all. So, and I know personally somebody, well, I don't know her personally, but I know she is in court today. And I know that she will be giving us some information. She's not news, but she is somebody that is trustworthy for information that comes out. Sorry, you guys, I'm just looking through here. I know Shelley covers this too. So let's see. Yeah, I've got a few people that there's nothing that's coming out yet, you guys. So believe me, when I do find anything, keep an eye on my community tab today. As things come out, I will be posting there. So I don't have to drag you guys back into the chat. But right now, there's some stuff that's being said, but it's not verifiable. It's just normal people like me and you that are saying their opinions and comments and whatnot. They're all waiting for somebody to come out of the courthouse to give them an update. So know that when that happens, you guys, I will be all over it and I will bring it to you. It will be posted in my community tab. Matt. Sorry, I was in a different screen and didn't see that. I got to scroll back up. There we go. Matt, please don't mention. I am so far behind in chat, you guys. It's unreal. And thank you to my mods for keeping everything PG here and removing stuff that, because I'm seeing some stuff that's been removed, and I want to thank you for that. We don't know what the daughters think of Shosho. I wonder if they dumped her or dived together. Okay, like I said, you guys, I'm way behind in chat, but I'm going through them as quickly as I can. Oh, come on. I don't think Barry's ever gonna give up her remains, ever. Even if he is found guilty and appeals and found guilty again, he still is not going to give up her remains. He is going to stick with the story that he is not guilty, did not do it for the rest of his miserable life. Yeah, Suzanne mentioned a few times that she knew that he was manipulating the girls. Okay, Cindy, no problem, hon. Love you. Thank you for being here. The real angel says, I'm so sad we can't see the trial. It's not a dead deal yet. The judge did rule on it, but they can appeal that decision. And I hope they do. Because this is looking a lot like the judge siding with Morphews on a lot of keeping this away from the public eye. And I don't think that's fair. So Full Circle Birthworks says, all I know is this entire town is not happy, especially if there is a dismissal. People like me whom have commented are totally freaked by Barry Morphew. Yeah. Yep, I agree. I wouldn't want to be living there. Sarah, no, they're not allowed to speak at all on the court grounds, nothing. And my chat just took off again. So no, Sarah, they cannot speak on the courthouse grounds, not in the parking lot, nothing. The judge has said absolutely not. Yeah, I'm watching the clock, Dana. That's okay, Jean. Nikki says, I bet Suzanne looks down at them and is just appalled. I bet you she is too. But I mean, I think she was well aware that the girls sided with Barry a lot. Oh, I believe the daughters go and see Barry daily if they can. They will take every single opportunity to go and see him. And I do believe that that will continue even when he's in prison. Real Angel Girl says Barry thinks he has it in the bag. I pray prosecutors are fighting for justice. They are fighting. But I think the prosecution really needs to put the hammer down here and, make it known that this judge is being very biased, not only towards the prosecution and what they can put in regarding certain aspects of this case, especially if the judge was ever charged with something like that or accused of. I think they need to get their shit together. Okay, Amari, I do believe he is under surveillance 24/7. I think he's watching her right from the windows of the Cushmans. We all know he's only living a football field away from his old residence in Puma Path, and there's a reason why he wants to stay there. If you're having problems getting to a certain area, Gunnison, to see your daughters, or your daughters are having a hard time getting to see you because of the snow in the past and everything, well, wait a minute, Barry, why are you even back beside your old house when you said your daughters were appalled, they couldn't go there no more, they were uneasy around there? Why would you go back and live in the same area that your daughters never wanted to go back to ever again because of what happened to their mother there? Like, you're stabbing one foot and bandaging the other, you know what I mean? Like, it just doesn't make sense. So he's there for a reason, and I believe that it's to watch the area where she is, where her physical remains are. The judge cannot revoke his bail unless there's a hearing. And I believe, I don't know. I don't really know how that works in Colorado. I'm in Canada, so I don't know what the rules would be there, but I believe if the judge feels that he is a danger, he could revoke it. Or if Barry does something wrong, breaches one of his conditions, they can revoke it. Yes, we have Marie Burks is here as a mod too, sis. Yeah, like what other reason would he still want to be in an area where your wife that you claim to love so much went missing from? Why would you want to go back there? Why would you want to live there at the Cushmans? Why? You're paying for a condo in Salida for Shosho. We all know by now, like everybody knows that you're with her. Why would you not stay in Salida where you could be monitored 24/7? And why would you even want to go back to the area of where your wife was apparently, in your words, taken by a mountain lion or abducted or whatever? Why would you? Why? Unless there's ulterior motives. Yeah, they always go back to the scene of the crime. Right? They always go back to the scene of the crime. And I believe he wants to keep an eye on where Suzanne's physical remains are. Says maybe you should uninstall it and reinstall it again. Okay, let me go and check you guys and see boom, if we've got anything else here, if anything is starting to come out yet from the court. So there's in Colorado Springs, there's a CSFD alert for today from 11 a.m. to 8 p.m. for high winds and low humidity expected. Call 911 if you see an active fire. So there's a warning to be wildfire ready, and that is in the Colorado Springs area. There's a lot of people commenting. There's a lot of things here regarding the Barry Morphew thing at this point. And there's one that states this is utter nonsense. At no time did Mr. Cahill say that he did not think there was probable cause to arrest or that he thought the defendant was not guilty of murdering his wife. We read that in Linda Stanley's reply. And we've got a lot of people going, Lord help Judge Lama make the right decisions and not dismiss the trial against Barry Morphew. So there's a lot of people really worried that this trial is going to be dismissed. You know, and Jules of Thought made a really good comment. If Susan, like they're trying to make it out that Suzanne was the abuser, she makes a comment and says, if Suzanne is the abuser, then why is Barry the one that's alive? Very respect. I respect that comment tenfold. And And how many of Barry's infidelities did Suzanne have to live through? But that is true. If they're trying to convince everybody that Suzanne was the abuser, if she was the abuser, then why is it Barry that's the one that's still alive? Right? Another thing I want to bring up, you guys, that my brother from a different mother, AK, brought up. And now I just lost my train of thought because I'm looking at something else. Ugh, I hate when that happens. Yeah, how can the judge throw out evidence of domestic violence that was spoke about between Suzanne and her friend Sheila? I don't know how that evidence can be thrown out, because in the probable cause affidavit, in his interviews and in his interrogations with officers, FBI agents, and cops, he admits to shoving her, to striking her. He admits to this stuff, to putting the gun to his head. He admits to it in the arrest affidavit when he was being asked questions and interrogated and interviewed by FBI and CBI and everything else. He admits to it. And yeah, he lied. Like, there's so many lies. He said that he never went on these sex sites and looking for women's sites. He did. He did. It was found on his phone, but he's denying it. So, like, if you can catch him in all these lies, and that's what I think that the prosecution is going to focus on, is all the lies, not only just the circumstantial evidence that they have. If he had nothing to do with it, why is he lying? Why is the story changing? Why is he leaving important points out? That's what I think their main focus is going to be, is on all the lies and the dump runs and stuff like that. Like, they have a lot of circumstantial, but I think that they're going to focus on if he was innocent, why all the lies. Yeah, Suzanne did document it in her journal, but he burnt it. Suzanne documented it, but and they're saying because there was no date or time on those texts to Sheila, they're not allowing them in. He also admits to the time that he stalked them when she was at the house with Sheila, and he parked up the road and walked in to spy on them. He gave some lame excuse for doing so. Oh, I was dirty. I didn't want them to see me before I showered. Like, bullcrap. So, I mean, there's a lot. There's a lot. Okay, let me get back to this, you guys. Let me see if anybody has come out of the courtroom yet. Nothing there. Let me check over here. Sorry, guys. I'm just checking through all of this to see if anybody is reporting anything yet. Yeah, see, from another one of the sources that I look at, you guys, they say we're very concerned about the exclusion of evidence, hashtag domestic violence, in the hashtag Suzanne Morphew murder trial. The only way for hashtag Barry Morphew to get a fair trial is for the jury to get the whole story. And there was a letter to the editor. Domestic violence needs to be admitted as evidence. Let me read this. Hang on a second here. Is this where it came out? It says, Dear Editor, we are very concerned about Judge Ramsey Lama's recent decision to prevent evidence of allegations of domestic violence from being admitted in the Barry Morphew trial. Research has identified a number of factors in abusive relationships that increase the likelihood of lethality. According to Minnesota Advocates for Human Rights and National Centers for Victims of Crime, the factors include threats of suicide on the part of the offender, which he did, availability of weapons, which he had, controlling and jealous behavior, which he had, escalation of violence, which he did, ending of the relationship. Those are the highest factors. Ending the relationship is particularly poignant indicator of lethality in domestic violence. Survivors who leave their abusers are at a 75% greater risk of being killed by their abusers than who stay. Preliminary evidence in the trial alleges that several of these factors were present in the Morphew relationship. The arrest affidavit outlines numerous examples, including Barry Morphew threatened suicide in text messages to Suzanne. He even told FBI agents that he held a gun to his head. Firearms were present and unsecured in the home. Several examples of controlling and jealous behavior, including controlling finances and monitoring Suzanne's phone usage. Text messages from Suzanne indicating that things were getting tense and escalating, and numerous attempts on Suzanne's part to leave the relationship. Any evidence related to these allegations is a critical piece of the story and should be admitted. Preventing this evidence from being admitted into the trial will not make it more fair for Mr. Morphew. In fact, it's the only way to ensure that the trial is comprehensive and fair and in its entirety. The Alliance is here to help. We know that hearing of the details of this case could be troubling for survivors of DV and other members of the community. Sincerely, Shelley, Executive Director. So, wow, that speaks volumes. That is a media outlet that was posted to. It was a letter to the editor of one of the bigger newspapers. Wow. I'm going to retweet that, you guys. So if you are on my Twitter, you can go and see that there. There's nothing that's come out yet, you guys. Nothing. But everybody is saying that they're praying that Judge Lama makes the right decision and does not dismiss this case. Would I be surprised if he did? No, because so far he's not only trying to keep everything from the media, he's keeping the media from being able to report on it the way that they always have, and in several other cases they have. He's sided with the defense on keeping the domestic violence stuff out. Yeah, the judge is biased. And I really do think that this needs to be addressed. Okay, so what I'm going to do, you guys, is I'm going to let you guys go for now. Get back to your day. And if I find anything coming out, I check, keep an eye on my community tab. Make sure you subscribed and hit the notification bell, and you're made aware when I even post to my community tab. Actually, those posts, you get notification of 99% of the time. Whereas sometimes when I go live, you don't get the notification. But I'm telling you, when I post to the community tab, you do get notified. So make sure you're subscribed so you will get those notifications. I will post there any information that comes out of the courtroom. If it's something major, I will jump back on the live. Yeah, I do really think he is biased. Okay, so until then, you guys, please take care of yourselves. Please stay safe. Thank you for being here. Thank you for going over all this information with me. Thank you for the super chats and super stickers. I appreciate it very, very much. It helps keep the channel going. And thank you to my mods for being top notch as always. Thank you so much. You guys do an awesome, awesome job. So please keep an eye. Make sure you're subscribed and keep an eye on that community tab. Don't forget, once this live ends, it will not be available for about 20 minutes, and then it will be back up public. That gives YouTube a chance to do whatever YouTube stuff has to do, and gives me a chance to enter in all my tags and description and so on. So if you are here and you are watching, it will be off for a bit, but it will be back up shortly so you can continue watching it. So take note of where you are, the timestamp of where you are if you are watching from the beginning, and you can jump right back on when it is back up. It's usually generally only about 20 minutes. Okay, so until the next time, you guys, please take care of yourselves. Stay safe. Love you to the moon and back. Bye-bye for now.